Hello, I'm Stephen Gold, the author of The Return of Breaking Law, the book what I wrote. And I fancy that if you're watching this, your relationship has broken. Well, I'm sorry about that. And I'm sorry about what may follow, not in formalising the break through divorce, nullity, civil partnership dissolution or court separation. That's a relatively easy bit. What can cause acrimony, expense, headaches, delay and wastage of precious time is, no, not complaining to BT, but sorting out the finances, or to give it the fancy legal title it likes, financial remedies. The other side may say, and now the end is near, so we face for final dissolution. My partner, I'll say it clear, I'll state my case of which I'm certain. My assets are nil, my income is low. We've lived a relationship that was full. We've travelled each and every holiday venue and eaten at all the best restaurants on my hard-earned cash. And more, much more than that, we did it our way. And our way is our future. So let's forget the lawyers. Let's forget the court. Darling, sign up here. Nothing for you and nothing for me. Ta-ra! Well, there's no stopping the two of you reaching an agreement for sharing property and income and not going within 5 square miles of a lawyer or a court of law. Disadvantages? Well, is the agreement fair? You may not know without reading my book, without seeing a lawyer or getting an indication from a family judge, which will be given well before a full hearing if a financial remedies application is made to the court. Has your other former half, by which I don't mean they've reduced in size to 1/4, you know what I mean, have they been honest about their current financial circumstances and their expectations for the future? And say one of you hands over property or money to the other without an agreement being approved by the court and made into a formal order, and 10 years later the other says, "That wasn't fair, I was stitched up, I'm going to court now." Well, that could happen. An order, which can be made by agreement, there doesn't have to be a contested hearing, will bring finality to the finances and mean that it can't be reopened at a later date unless there's been dishonesty by the other party, they failed to tell you something relevant, there's been a terrible mistake, or some intervening event has made the order a bit of a nonsense, like coronavirus perhaps, which I look at in the book. Or say the order includes maintenance provision, £500 a month until you take in a lover, and there's a good reason for ending it, increasing it or reducing it. If you're going to reach an agreement without an order, you silly boys and girls, at the very, very, very least, get your other half to complete and hand over a form which they would have had to complete and hand over with a court application. It's called a Form E. You can source it online, giving the fullest detail of finances, and then you'll have a record of any lies and misrepresentations to put you in a strong position to go belatedly to the court and say, "I was tricked, Judge." In the vast majority of cases, there will be a court application, and in the vast majority of cases, there'll be an agreement at a preliminary stage. The second preliminary stage is a dispute resolution appointment, where you troop along to court or to your laptop or smartphone for a remote hearing, with lawyers if you have them, and with that cuddly judge or give you that indication about how the case should settle, in his opinion. Bang your heads together gently so as not to cause concussion, and plead with you to be sensible and stop arguing about who gets the back editions of OK magazine and those old Max Bygrave CDs. You can't afford a lawyer. Well, you don't have to hire one for the whole shooting match. No, you can take in one for initial advice and or for that all-important dispute resolution hearing, and if a case hasn't settled, for the final contested hearing. Yeah, you can dip in and out with a lawyer, and these days you can hire a barrister directly without having to go through a solicitor. Much more on this in my book. Plus, in the book, how and where you can borrow for legal fees, and how, if they can afford it and you cannot, how to get your other half to foot all or some of your legal bill in advance through an order of the court. With a court application, you'll get an opportunity to put written questions to your other half about any points which are in issue. There's a template questionnaire in the book to give you some ideas, like the respondent should produce copies of his tax returns, forms P11D, as to benefits and expenses not put through the payroll, and all notices of assessment of tax issued by Her Majesty's Revenue and Customs in relation to the last 3 tax years. If you stumble across documentation in your other half's desk revealing 20 foreign bank accounts they haven't disclosed, how do you play it? That's a tricky situation, as I explained in the book. And in the book, you'll find the latest law on applying for temporary maintenance when you cannot wait for a full hearing of a case. That's got somewhat easier. And if you find, as well you might, that court hearings are taking an eternity, the wait was long enough before the pandemic, and inevitably it's got worse since. If you find that, there's an alternative where you can afford it. That's to have the case tried by a private arbitrator, be a lawyer, a former judge, whose decision is then likely to be endorsed pretty quickly by a formal, enforceable court order. Another advantage of this route is that you can be sure of privacy and no headlines should you pour water over the other side's lawyer. Useful if you'll be coming up in a forthcoming episode of Love Island. Well, do read my latest book. It should help you. Good luck.